I'm Melanie Stancliffe from Pritchard Englefield Solicitors, an international law firm based in the City of London. We're passionate about helping our clients understand their legal rights and their risks without jargon. Employment law is frequently changing, and this can cause difficulties for even the largest businesses to keep up. I want to help demystify that for you. Firstly, there's been an increase in the period of time that an employee has to work to claim that they've been unfairly dismissed. An employee who started work since the 6th of April 2012 must now work for 2 years before they have this right. An employee who started work before this time only needs to work for 1 year. This gives employers greater flexibility in how they dismiss staff in those early years. But there is a pitfall. If the discrimination issue is raised, then you should be very careful. For employees, this first 2 years of their employment is a very vulnerable time. They can be dismissed without a fair reason, without a fair process, and without recourse. Secondly, from October 2012, businesses have had to start enrolling all their staff into pension schemes. This is being brought in over the next 5 years. For employers, the record keeping and administration is of concern, particularly as there are different categories of employees with different rights. For employees already struggling with high costs of living and stagnant wages, there is a real risk that they will have to opt out. So let's look ahead. What's on the horizon? Proposed legislation will allow businesses to have frank conversations with staff where the relationship isn't working out, and for those conversations not to be heard in the employment tribunal. But the protection isn't complete. It will not be available if the conversation was discrimination, there was bullying, or a breach of the employee's contract, so there is still uncertainty. Secondly, ACAS will now need to be informed when an employee starts a claim. ACAS is already stretched, so there is a real risk that employees who don't know their time limits could run out of time. Employers may also face a penalty if they breach an employee's employment rights maliciously or negligently. The penalty would be 50%, whatever compensation they have been ordered to pay. Lastly, it will be possible for businesses to hire employees soon who give up their employment rights to claim unfair dismissal, redundancy pay and maternity rights. In exchange, the employees will receive between £2,000 and £5,000 worth of shares in the company that employs them. There will be no obligation for employees to become employee owners. However, I think that it's likely that many will do so, and perhaps unwittingly give up their most basic employment protections. So employment law can be tricky. Both employers and employees need to be careful and take advice. My name is Melanie Stancliffe from Pritchard Englefield Solicitors. If you need jargon-free advice, call me.